Hello, today we're going to be continuing our discussion of the Servicemembers Civil Relief Act, again the SCRA. Last time we talked about some of the basics of the SCRA and in large part what immediate relief is provided for the service member. The main relief is that the service member is appointed a lawyer immediately and has the ability to request a stay or a pause in the proceedings for up to 90 days. Today we're going to look at things a little bit from the perspective of the other client, or the other party, the non-service member, about what that person's remedy is when the service member cannot or will not participate. As we talked about last time, the service member can request a stay of 90 days, and assuming that's granted and after 90 days the member is still not available, he can request another stay. But at some point there's going to be an end because the other party does have a right to proceed with his or her case. So we're going to talk today about what that other party might do when the service member is unavailable or unwilling to participate. Okay, so again, the service member, a situation where the service member is not available, let's say they're overseas or in a combat zone. Let's take a paternity case, for example. The mother gives birth in the U.S., the father is deployed and in a combat zone, and the mother files a petition to establish that service member as the father of the child. What will happen is, upon the filing of the petition, the mother must make a statement as to whether the potential father is in the service. If so, the judge is required to appoint a lawyer for the potential father. If a lawyer is not appointed in a case like this, or for example in a divorce or something of that nature, any judgment obtained by the other party is void, and that means it's not that it can be overturned. It means it didn't exist in the first place. Any judgment was a legal fiction, like it never happened. So what the appointed lawyer for the service member will likely do is try to contact the member and inform him of that, a paternity case has been filed against you. Try to get some information from the service member and file the requested stay for the case. Assuming all the requirements are met that we talked about last time, the stay will in all likelihood be granted. If there is a situation where the appointed lawyer cannot get in touch with the service member, or the service member just won't cooperate, then the other party does have some legal remedies, which we'll discuss. Keep in mind that the requirement for the member is only that they are able to, quote, meaningfully participate, end quote, in the case. It doesn't mean that the member must be sitting in the courtroom every single time there is a hearing. The member can participate in various ways, through email, through telephone, through video conference. Obviously, in most recent months with the COVID virus, a lot of courts are willingly or unwillingly, but they're doing it, getting more comfortable doing video conference hearings, etc. And those are generally sufficient in most cases. So if the service member can participate in that way, the stay may not be granted. But let's assume that either the stay is granted and then the petitioner, in this case the mother of the child, wishes to move forward. The 90-day period ends and the service member refuses to participate, can't be contacted, etc. The petitioner can request a default judgment. And a default judgment simply means that the other person had a chance, the defendant, or in this case, had a chance to participate, didn't they refused to participate or they couldn't be found or something. So the petitioner is entitled to a judgment even though the other person didn't participate, excuse me. So what does the petitioner, the mother in this case, have to show? That the efforts were made to contact the service member, or that the member just refuses to participate, or that they didn't follow the SCRA mandatory requirements for obtaining the stay. So assuming that happens, a default judgment can be granted. In this case, let's say the father could be determined, or the service member could be determined as the father. So this could also happen, for example, in a divorce proceeding. The spouse, in this case, the non-military spouse, will be granted a divorce even though the service member doesn't want it or might not know about it, etc. What happens later, though, if the service member, or when the service member does find out about the judgment? Does he or she have any remedy? Yes, they do. Under the SCRA, there are 4 things the service member can show even after the judgment is granted to, in essence, get relief from the judgment or overturn it. The member has to show, A, that he or she was not aware of the judgment or of the case, that he or she was on active duty at the time the judgment was granted, that his or her duties prevented him or her from active involvement in the case, and that the member actually had a legitimate defense to the case. So that last piece is a little bit strange in the sense that the member can simply say, for example, I didn't want a divorce. That's not sufficient because the member doesn't have to agree to a divorce. As long as one person in Wisconsin wants it, they will get it. But some of the other provisions of a judgment, for example, the division of property or the custody of children, etc., in that case, the member could have a legitimate defense and say, no, I don't believe that the property should have been divided as it was under the default judgment. So what the member would do would be to file, at least in Wisconsin, a request to reopen the judgment, request for relief from the judgment, and cite the Servicemembers Civil Relief Act as support, along with the relevant Wisconsin laws, to obtain relief. Obviously, the best situation is for the member to cooperate, if at all possible, with his or her appointed lawyer, or certainly a lawyer that they choose, to prevent a default. It's not always easy to overturn a judgment that was granted. Judges don't like to do it. They don't like to see cases coming back, sometimes years after the fact. And also, in the meantime, certain things may have happened. The other spouse may have obtained some funds and spent them, or a house may have been sold, or there may have been some other economic consequences that really can't be fixed. So for members, if at all possible, they should participate with their appointed lawyer, even to ensure that the stay is granted and there is some participation in the civil case. But if they're not, or they can't participate, there is this other provision as a last resort. We'll continue going through the SCRA provisions over the next couple of blogs, because this is, again, an extremely important statute, federal statute, that has significant effects on family members who are in the service.